A former school resource officer and record-breaking basketball player confesses to sexually assaulting multiple students. But what really is making headlines, his sentence. After taking a plea, the ex-cop ended up with only probation, so he avoided prison time. And now, prosecutors are recommending he also avoid the sex offender registry. The defendant in this case is Jamel Bradley, a one-time star basketball player at the University of South Carolina, who still to this day holds the school's record for most three-pointers. His basketball career ended after college, though, and that's when he became a school resource officer in Columbia, South Carolina. Bradley worked at Spring Valley High School for 9 years, and during that time, at least 5 complaints were made against him. 2 colleagues reported they saw Bradley alone with a female student in a secluded parking lot. There were others who sounded the alarm off too, some parents, a coach, and even another SRO who worked at the school. That report came within the first year that Bradley worked in the high school. The other officer reported that Bradley was acting inappropriately with female students. All of this largely went ignored, though. Bradley was moved to the district's elementary school, then the middle school, and eventually the jail. But during that time, he still kept his job. Then, in 2019, a former student came forward with the allegations that Bradley had an inappropriate relationship with her when she was in school. There were not criminal charges in that case, but it did lead to Bradley finally being fired as an SRO. He served 12 years total with the sheriff's department. That same year, though, Bradley was finally arrested and charged with criminal sexual conduct. That charge stemmed from an incident back in 2018 when Bradley allegedly assaulted a 17-year-old Spring Valley High School student. At the time, the Richland County Sheriff told reporters that the assault didn't happen on school grounds, but it did happen in Bradley's patrol vehicle while he was still in his deputy uniform. In this case, the 17-year-old student says she consented to the relationship, but under South Carolina law, a student cannot consent to sex with someone who has authority over them, meaning a teacher or an officer. And while there may have been consent in that relationship, Bradley's other charge came from a non-consensual encounter with another student. Prosecutors say Bradley went to the girl's house multiple times and eventually took her to a secluded area where he forced her to kiss him. And eventually he took her home after she told him to stop. These incidents happened more than 5 years ago, but Bradley's sentence was finally handed down this month when he pleaded guilty to both charges. Bradley faced up to 15 years in prison, but instead got a 5-year sentence that was suspended and only 3 years of probation. To make sense of this sentence, we sat down with criminal defense attorney and former prosecutor Matt Mangino. There's a lot to unpack in this case, but let's start with a major headline, the development that happened just this week, that a former school resource officer, an officer of the law who's set in these schools to protect children, actually admits that he harmed children. He sexually assaulted multiple of them. He pleads guilty and gets a 5-year sentence, but then that turns into probation. There's a lot of outrage about this outcome. What are you thinking?
Well, I can understand the outrage. I mean, this is a school resource officer, someone who's trusted within the building, someone who has access to young people, and he takes advantage of that access that he has, and sexually assaults 2 um, young children over a period of time, and ends up with essentially a slap on the wrist. And I can see why families would be upset about the outcome of this investigation and prosecution.
And Matt, you mentioned something really important there, that this defendant is a school resource officer. That is someone who is placed in the school, again, to watch over these kids. If they have some sort of issue, they should feel comfortable and safe going to the school resource officer who could then provide them just that, resources to help them. And what we're finding out in turn is that he actually assaulted these kids and admits to it. I mean, there's so many different levels here, but do you think that this is a betrayal of trust?
Well, he certainly betrayed the trust. So imagine, these school resource officers are supposed to build relationships with students meaningful, trustful relationships, so that they're people that students can come to if they have a problem, or more importantly, if there's an issue in the building, maybe with other students, or the potential for there to be some sort of catastrophic incident in the school. So this trust level that's built up, and that they're trained to cultivate with students, in this situation, got betrayed.
Something that's been highlighted throughout this entire case: the multiple people who sounded the alarm, but their warnings fell on deaf ears. What's really tough about this case in particular is that it wasn't an isolated incident. So we have multiple incidents of this, but then in addition to that, there were warning signs. I mean, this happened over almost 10 years, and at least 5 complaints had been filed ahead of his arrest. So that's people like parents, an administrator, a coach at the school, even a fellow deputy said, "Hey, I think something's going on with this guy. He's acting inappropriate. He was seen in parking lots that were dimly lit, secluded with female students." This was all reported. Do you think that these red flags were just ignored?
Well, they certainly were. I mean, anytime that there is a complaint in a school district about inappropriate conduct with students, whatever that conduct may be, and in this situation, the people who are observing this, feel uncomfortable by what they observed, to the point that they reported the conduct. And these weren't just people who parents who maybe were unhappy because their child was disciplined. This included other deputies. This included a coach, and obviously parents who not only were sort of murmuring about what was going on, and while this doesn't seem right to me, but they made formal complaints. And for a school district to fail to thoroughly investigate those complaints is really another huge failure in this whole situation.
For these complaints that were ignored, both the school district and Richland County Sheriff's Office were sued in civil court over accusations of gross negligence. That suit was settled in 2020. And we have seen at least one civil suit in regards to this case. But as we know, sometimes with survivors of sexual assault, not everybody comes forward at once. They do it in their own time when they're processing whatever it may be. So it is possible that more students come forward later on and say, "Hey, I was affected by this." And if that's the case, could there be even more civil lawsuits to come?
Yeah, I mean, there's a lot of reasons why a student who was a victim may not have come forward. I mean, they're embarrassed, and they shouldn't be, but ultimately they're embarrassed by the whole situation. They don't want the public scrutiny. They just want to block this from their memory and move on with life. And that's why there's extended statutes of limitations for victims of child abuse, so that they can, particularly sexual abuse, so that they can, at some point, long after this incident occurred, sort of reconcile it with themselves, and then move forward, to try to get whatever, relief is available to them, and make sure that things like this don't happen in the future. So yeah, I don't. There was a lawsuit filed. That lawsuit was settled. We don't know the specific terms of that settlement. Um, that doesn't mean that other plaintiffs are not going to come up in the future, and file lawsuits again. And certainly, I believe that the school district and the school was named as defendants in the prior civil suit. So I wouldn't, be surprised if something like that developed again in the future, if there are additional victims in this case. And also, there has to be scrutiny of the sheriff's department, the school resource officer, and if there were complaints, if the chief knew, for instance, that there were other deputies who had concerns and didn't thoroughly investigate that, you know, depending on the immunity statutes, um, there may be liability for the sheriff's department as well.
In the case of one of the survivors, Bradley's advances were unwanted, but for the other student, it was almost a shared relationship of sorts with Bradley. And that's a shocking pattern we've seen before. Unfortunately, this is something we cover kind of a lot on Law and Crime. I mean, honestly, usually it's teachers who abuse their trust. I mean, they're close to the students, so they see them a lot. They end up being charged with statutory rape, whatever it may be. But I'm wondering if their cases are kind of similar to this one in that not only did it happen in a school, but also there were elements of grooming. I mean, these are vulnerable children who respect their elders, who respect the people of authority, teachers in past stories, and in this case, an officer of the law. So I've seen a lot of grooming in past stories. Do you think that could have been happening here, that grooming was at play?
Well, it more than likely was a factor. You know, in order to have a even a consensual sexual relationship with a 17-year-old student, there has to be some form of building a relationship with that student, and in that grooming process, it's not as though this comes in and this was sexual assault by force and it happened one time and he forced himself on a student. This is something that developed over time, and that's essentially what grooming is: building that relationship, that trust, so that ultimately you can take advantage of a student. And so the concern, Sierra, as I see it, is there's been an explosion of school resource officers. Obviously, school districts and parents are concerned about mass shootings, and one of the ways that school districts have you know protected themselves or tried to protect themselves is through the expansion of armed guards and school resource officers. And unfortunately, we know from other sexual assault scandals, whether it's the Catholic Church or Boy Scouts or any other organization that's been scrutinized, that sometimes people go into those positions because they want to have contact with young people, and their intent is sexual gratification from these young people. So I think that we need to make sure that we're properly vetting school resource officers, and we're looking at whole. I mean, I think there's something like 30,000 school resource officers. People who are in school districts, in schools all day, every day, and we're hearing more and more about these cases. Whether it's in Georgia, Minnesota, Kansas, they've all had cases where they've convicted school resource officers for inappropriate sexual contact with students, and there's been more than 200 arrests of school resource or officers across the country for this type of conduct. So we got to make sure that the people we're putting in schools, that their ultimate goal and what they want is the protection of the children, not an opportunity to victimize them.
And the statistics you pointed out are just staggering. They're really disturbing to even think about, to hear about. These are vulnerable children who should be able to trust the people within their school. So it's honestly just tough to hear. But there was some form of justice in this case because our defendant here, Bradley, was charged. And one of the charges, sexual battery against a student ages 16 to 17. And I had previously mentioned I've covered a lot of these cases in the past involving teachers and students, and a lot of the time I see charges like sexual assault or statutory rape. But this specific charge is interesting to me because not only does it lay out this was a student, but also ages 16 to 17. And I'm wondering why that may be in the charge. Do you think it's just to be a bit more specific, or that it's more severe that it was a student and one that was a young age?
Well, as I understand the way these statutes are drafted, and every state has a different way of going about it, but generally, what it is that young woman. So let's say she's 17 years old, and she would, let's say she met an adult man someplace else, and they had a relationship, and that wouldn't be against the law. The fact that she's a student, makes it a crime, because what it's in Pennsylvania where I practice. We have institutional sexual assault, which means a 17-year-old student or even an 18-year-old student can't consent to sex with a teacher, with an administrator, with a school resource officer. Any sexual contact, consensual or not, is a violation of the statute. And I'm sure that's a similar um, statute here, because, again, you had a 17-year-old who acknowledged a consensual sexual relationship with the school resource officer. But the mere fact that she was a student, she cannot consent to that type of contact. And any contact like that is a violation of the statute.
Years after the charges were filed, we finally saw a resolution in court. So let's fast forward to the end. It ends up being a plea deal. Our suspect here, Jamel Bradley, is sentenced to 5 years in prison, but that's suspended. And in the end, he's just given probation. A lot of people are really upset about this. I have some questions too. Do you think that's a normal sentence? Is it just? What are your thoughts?
Well, I mean, certainly it doesn't, the punishment, at least in my eyes, doesn't meet the seriousness of the offense. I mean, it's a 5-year suspended sentence, 3 years probation. Uh, but there are a lot of factors that go into making a plea agreement. Okay. Um, Maybe you had reluctant victims. Maybe they didn't want to testify. Maybe they didn't want to relive this in court. We know that at least the one relationship was acknowledged as consensual. 17-year-old. Maybe she didn't want to testify. So there are a lot of factors. In this case, the victims were in agreement with the plea, so they weren't opposed to it. So this wasn't something like, the district attorney coming and say, "Hey, this is what we're going to do." You know, Too bad, suck it up. This is how we're going to resolve the case. That's not the situation here. The victims um, consented to this agreement. The thing that I thought was a bit ironic was reading the news accounts, and the chief of or the sheriff said something to the effect, "I would have liked to have seen some jail time here." When this was a guy who was overseeing an office where complaints were made, and they did nothing to look into it. So a little bit of grandstanding there. Uh, but sometimes it's difficult to understand and really know the dynamics of a plea agreement, and why in this situation it seems so lenient.
Another interesting aspect of this case is that the solicitor's office in South Carolina, which is like the DA or the prosecutor's office, they recommended that he doesn't need to register as a sex offender. So, usually, if you're convicted of a sexual related crime, you have to register as a sex offender, especially if it's children, whatever it may be. But the solicitor's office in this case in South Carolina recommended he doesn't need to register as a sex offender, and all he needs to do is undergo some sex offender counseling. What do you make of that?
Yeah, I mean, again, this is a person who, not once but twice victimized students who essentially were in his care. You know, you know, Parents send their children to school thinking that they're going to be safe and that they're going to be protected. And then actually, an individual who's been hired by the district to provide that additional layer of security and you know watching out for students. Parents are supposed to have a higher comfort level because we have a school resource officer in the building, uh, and that person violates that trust, and you're not concerned that he could do the same thing again in the future. That the public should know at a minimum where that this person has been a sex offender. whether it's the neighbors or another employer or whoever it is, that they should be able to go to the registry and examine it and find this guy who uh, is convicted of assaulting two separate children over a period of years.
In the end, the judge ruled against the solicitor's office, saying Bradley is now required to register as a sex offender. Reporting for Law&Crime, I'm Gillespie.